All right, guys. Welcome. My name's Laura Husking. I'm the Director of Marketing for Generations Counseling and Care Management. We're a geriatric care management firm that's been providing care management, advocacy, and psychotherapy services in New York and New Jersey for over 30 years. We also have a real passion for community education, which is one of the reasons why we're here today. So I'm very excited. We are partnering with Autumn Years, the Bristol, Organized with Lisa and Jason Marks to bring you this wonderful series called Get Control of Your Life. Besides today's program, we have two other upcoming programs. On May 18th, we're going to give you a chance to declutter your life with our professional organizer, Lisa Harris from Organized with Lisa. And on June 15th, we're going to sweeten your life with Heidi Gross from Autumn Years. We're very excited for those two programs. Today's topic is protect your life. So we have two fabulous experts who will discuss why planning early is an important part of protecting your wishes and your assets. So we're also going to discuss how to start talking to your loved ones about life care planning and what steps you need to take to make sure that you're protected in all facets of your life. So I know how hard this can be because we had this issue with my mother. She was diagnosed with a very rare form of cancer. And because she was really young, we had no conversations about life care planning, about her wishes. So I know how hard it is to make those kinds of decisions. And I think that you never want to be making decisions in crisis mode because it really adds a lot of stress. So that's what we're here for. We're here to take some of the stress off your shoulders and kind of talk to you about these decisions before they become so stressful. So before I introduce the lovely speakers I have today, I just want to let people know, feel free to send your questions in the chat box. I won't be interrupting the speakers until they're done, but I promise I'll be keeping track of all of the questions. And if you want to send them anonymously, you can choose my name in the drop-down box, so you don't have to choose to send it to everyone. So we want to protect your privacy. If you prefer to be anonymous, you can send me a private message on the chat box. All right, so our first speaker today is Stacy Maines. She's the Director of Care Management for Generations Counseling and Care Management. She has her master's in social work from NYU, and she's a licensed social worker. So she has over 20 years of experience in the senior care field, and she's incredibly passionate about advocacy and facilitating communication within families. Not only does she have a strong clinical training, but she's worked pretty much in all aspects of long-term care, including skilled nursing, assisted living, continuing care communities, hospice, and home care. So Stacy, please take it away.
Thank you, Laura, for the wonderful introduction. And hi, everybody. It's nice to be sort of together in this format. I'll be speaking about a topic that is very important to me. I'm very passionate about communication. I think that this is, when we talk about getting control of our life and talking about the future, it means taking small steps now. There's no way we can always prevent a crisis. I wish we could. I wish there was that magic wand to just sort of prevent any of those bumps along the road. But communicating effectively ahead of time really makes those bumps a little bit smoother. It takes some of the emotion out of things at times, or it manages the emotion a little bit better. It makes that crisis more manageable, and it gives us a sense of control. And having a sense of control in a situation where you really don't have any is, I think, one of the best things we can do for our future. So I'm going to share a little tidbit story, which may sound weird as why I'm talking about this at a time of talking about life care planning. But my sister-in-law and I were pregnant at the same time. She was pregnant with her first. I was pregnant with my third. We were due within days of each other. This was almost 14 years ago. And, I'm pregnant with my third, something, I got this. I know the drill, the routine, it's all good. It's going smoothly. Everything's fine. She's pregnant with her first. So she was a little more anxious. So we were meeting for lunch one day together and comparing notes on, baby names and when we were going to stop working and nursery things and which stroller we were having and everything else. And she said, "Did you write your birth plan?" And I said, "My birth what?" She said, "Your birth plan. Did you write your birth plan?" And I said, "Oh my gosh, she's a nut job." I said, I plan on giving birth and leaving the hospital with my baby, and that's my plan. She was horrified at my plan. She then proceeded to review her multi-page document of the plan that she and my brother-in-law had for the baby's birth. And she talked about her wishes for pain management. And she talked about not wanting to have a C-section. And she talked about who was allowed to be in the room with her. And she talked about things that my brother-in-law could say and things that he definitely should not say in the room while she's in labor. She talked about the order of who should be called at what time, because she has 4 sisters. So there was a definite order of who should be called first so that everybody maintains the peace in the family. She talked about which doctor she preferred. She talked about what things to bring with her to the hospital and everything else. And I kind of chuckled and laughed and says, oh, wow, this is crazy. Then I left there and I thought more about it. And I said, okay, well, maybe this isn't so crazy, because having gone through 2 other experiences at that point, and remembering that my poor husband said the word relax to me while I was in labor, and I don't think he said the word to me again in the past, 20 years. It would have been nice to have some of these discussions beforehand. It would have been nice to have some of these discussions with the doctor to understand what would have happened. So my sister-in-law creating this birth plan gave her and my brother-in-law an opportunity to talk about what was most important. It gave them an opportunity to talk about things that you don't want to be talking about when you're in the throes of labor, when you're in the throes of a crisis. And even though she did end up having a C-section, it gave her the opportunity ahead of time to have this conversation with her doctor and understand different situations that may come up because of her condition, of whatever was going on in the hospital and anything else. So it gave a sense of control at that time, even though it didn't prevent anything from happening. It didn't necessarily create certain things, but it gave a sense of control. And I've used that example every time I talk about advanced directives, every time I talk about planning in terms of healthcare and senior care, because I think it's such a good example of taking some control of a situation that you don't always have total control over. So when we talk about advanced directives and life care planning, so much of that starts with a conversation. So before you're going to the attorney and before you're creating these documents, it's really important to start having the dialogue with your family to understand what's most important for you. And there's 2 ways of doing this. I think there's more of the formal conversation. Either you've already created the document and you want to review that with whoever your healthcare proxy is, with everybody else in your family, and say, these are my wishes. This is what's important to me. This is what's in here. Review it with your doctor. And really have an understanding of what's in that document, where the document's going to be kept, what different things mean. But in some ways, more important is the informal conversations that happen. So it's not, let's have everyone over for dinner, pass the salt. By the way, how do you feel about a feeding tube? It has to do with some more informal conversations of, for example, what does quality of life mean to you? So many times when I read advanced directives, there's a statement in there that says, if I no longer have quality of life. Well, what does that mean? Because of everybody in this Zoom room right now, everyone may have a different definition of what quality of life is now and what they anticipate it being in their 80s and 90s and well into their hundreds. What is most important to you as you age? What does independence mean to you? These are values. This is less about medical terminology and more about what your values of life are. What's most important to you? I was in one of my years working in assisted living and memory care unit, and we were going over an advanced directive, and there was some family conflict about, it wasn't a feeding tube or DNR, but it was some type of invasive measure, somewhat invasive measure. Then the family wasn't decided whether mom would really want this. And the line in her advanced directive is, if I don't have a quality of life, then I wouldn't want anything done. And the daughter said, well, mom has no quality of life. She doesn't recognize us anymore. She doesn't know where she is. She doesn't know who she is. She thinks she's a little girl. She's, thinks she's waiting for her mom to come home and her dad to come home from work. And this isn't a quality of life. And she's incontinent, and all she does is shuffle up and down the halls. And I said, okay, that may be true. But at the same time, here's what we see. Here's someone who every single day went to dance and went to music in the assisted living. And she led the dancing, and she danced around, and she got all dressed up for dinner every night because she couldn't wait to see her dad when he came home from work. She was happy. She was engaged with other residents. So yes, it was sad for her family, who didn't see that she was the person that she was at one point. But for her in that moment, who's to say whether or not there was a quality of life? So I'm not here to judge either way, to say there was a right or wrong answer, but it was a discussion of, well, what does quality of life mean? And very often that's a term in an advanced directive. So I think it's important to have these discussions through life of, what does it mean to you? What does quality of life mean? What does independence mean? What means the most to you as you're aging? I think the generation that, when I first started in senior care, that generation didn't expect to live into their 80s and 90s and 100s. So they weren't thinking about assisted living. They weren't thinking about living at a time where they were maybe living with some disabilities. So these conversations didn't happen. We don't have an excuse. I think that this needs to be something that everyone needs to be more comfortable talking about, because aging is now, the assisted living communities now, I feel like, wait, when can I move in? Because these are pretty nice and fancy. And the food's really good, and there's all these options and everything else. So I think it is more important to be able to be comfortable having some of these conversations about what happens as we age, and what happens and what's most important to us. What do we value? These are also conversations to be having with our doctors. So as you're at your doctor and you're understanding what your medications are, understanding what different prognosis and diagnosis you have, these are also important things to maybe then, if you already have an advance directive, be looking at it and saying, do these things still hold true? Do I need to make a change in my advance directive? Do I need to alter something because now there's a new diagnosis that changes this? Or there may be new things to think about. If there's a diagnosis that may impact your ability to speak at some point, your ability to properly digest food, then it's more important to maybe having some of those conversations about what feeding may be, what eating may be, what activities you may want to be doing or not doing. So I think these need to be ongoing conversations that we're having. Again, formal and informal. So sometimes looking at the documents ahead of time, looking from a physician, what they're saying, but also just getting to know each other a little bit more and getting more comfortable talking about our aging experience and what this means to us. I often joke on these things. Certainly my kids and my family is the extreme. I've worked in senior care, my children's entire life. So they've grown up hearing me talk about all of these things, and they're hearing me talk about dementia, hearing me talk about UTIs and feeding tubes and hospice. And so it's almost a little too comfortable at my dinner table, but they'll talk about, yes, we know you want to just go to the music programs and the sing-alongs, and that's kind of your thing, and you don't want to wear pants with words on your tush, and we know that, we got it, and most importantly, Mom, you want us to be able to get along and agree on whatever it is you are, and whenever you do. So these are conversations that we've had, and it's not big heavy conversations, they're lighter conversations. This is what's important to me. We're definitely more comfortable talking about it because of my job and because they've grown up hearing this, but I think my goal is to have everyone be a little bit more comfortable. So I think if you've just created that document, again, making sure everybody has a copy, making sure the healthcare proxy knows that they're the healthcare proxy and that they're comfortable in that role. And that would be before you name them the proxy and everybody signs everything. Too often I've seen, the hospital and somebody pulls out an advance directive and one child assumes that they're the healthcare proxy because they're the oldest. And it turns out that it's the middle child or the youngest child, or maybe a niece or nephew that's the healthcare proxy. And so these are conversations to have ahead of time so that everybody knows who's responsible for that discussion, for who's responsible for those decisions. Make sure that person is comfortable in the role. And I'm sure, Jason may touch on that as well in terms of some of the legal components of that. But I think it's not a birthright. I think very often I've had too many people say, well, my firstborn is going to, obviously be my financial power of attorney, my healthcare proxy, and it's interesting. I always say my sister is firstborn. She gets the front seat whenever we're in the car with my mom. That's a birthright for her. And she does, she inherited holiday dinners, but I'm the healthcare proxy. That's not a birthright in terms of the healthcare decisions. My parents decided that because of my career, because of whatever. So have those discussions with people and make sure they're comfortable with that role. The other thing is making sure someone understands that it's not them making the decision. It's them advocating for you and making decisions and being your voice when you can no longer be the voice in the room. So if that person is your healthcare proxy, it's really important that they know what your wishes are, what's most important to you, so that they can advocate for you and that they feel comfortable making that decision. Again, and the informal would be more of, what do you value? What does life mean to you? Who do you want caring for you? This doesn't have to be big formal. I'm inviting everybody over for dinner this weekend so we can talk about, what's going to happen if I need someone, if I need live-in care and whether or not I would want you bathing me. These are informal conversations. As you hear about another loved one going into, a facility, you may say, okay, well, how do you feel about that? And if you had the option, what would you want? Or do you, how do you feel about being home? People often assume that everybody wants to age in place at home, and that's often not the case. Many people would think that, if I can't live my life as I was at home, I'd rather be in a community where I can feel more independent and have more options and have more of the someone kind of supporting me a little bit more. So have the conversations, don't make assumptions about things that may have been said 30, 40 years ago. The more you're having the informal conversations, the more this becomes part of the dialogue and part of the comfort, then I think the more when a crisis happens, and you feel like you know the person, you know what they would want. That's really key to this, because if the first time you're reading that advance directive is in the emergency room when someone's asking you to make a life-altering decision, or that's the first time that you've ever really started to discuss with someone what they value the most, then it's going to be more of a crisis, and it's going to be much harder an emotional decision. If this is something that you've been discussing your whole life with them, then I think it makes it a little bit easier, take some control of that situation. So I don't know if there's any specific questions. We're going to have questions at the end, but that's the overview of communicating about things ahead of time.
No, thank you so much. I think I will ask you at least 2 questions before we move on to Jason's program. And I think one of the things that you pointed out that's just so, it seems so logical, but not all of us think of it, is making sure that the person is comfortable in their role. Because I dealt with this with my mom. Now, my brother and my sister and I all have very different strengths. And I always equate this as, well, you wouldn't hire a lawyer to do an accountant's job. So if somebody has a certain skill set, you shouldn't be asking them as one of your fellow caregivers to do something outside their skill set, because it only increases resentment and contention. So that kind of leads into my question is, what happens if family members don't agree with each other?
Okay. That's such a good question, because we see this so often. So again, as much as possible, if you can have the conversations before, then it helps to tweak out some of that disagreement, and some of that, feelings around it. I think at the time, and again, Jason may touch on some of the legalities of that and sort of the different advanced directives and who's named. So I'm just going to focus on from the social worky aspect of the communication and trying to minimize the challenging family dynamics that occur. So I think it's important to sit down and really talk about, this is not somebody's personal decision. It's what would mom want, for example, and really trying to get an understanding of what they would want, which again, even that sometimes isn't, everyone may have a different view because they have a different relationship and a different perspective of their mom, for example. But I think the more you're talking about things and really trying to come to an understanding, asking the medical professionals, getting maybe some additional support from some doctors, or from a care manager, from a social worker in the hospital, helping someone facilitate this dialogue so that you're taking the emotion out of it, trying to take some emotion out of it. All too often when I do a lot of guardianship cases, I do a lot of, conflicted family cases, and to watch these adult children arguing over a decision about mom, and you could almost just replace it with whatever toy they were arguing over when they were, 8 years old. Because a lot of, and I think especially with siblings, what happens is those emotions come up and you're fighting over the attention of that parent that in some ways siblings kind of do their entire lives. So I think trying to remove that out of it and understand, okay, what exactly are we talking about? And often you need some support with that. That may not be something that, you can do on your own. And I've seen the closest of siblings still have arguments in these situations because there may be differing opinions. And it's not just about, obviously it is in part in terms of who's making the decision, but I think ultimately it's really important to try to make that decision together and to try to have everybody in agreement, because adding the challenges of an argument, of disputing, of challenging things, of multiple people talking to doctors and nurses is really just, again, adding more fuel to the fire of that crisis, so to speak. So getting some professional support if you need it with that conversation is important.
Yeah, and I'll make sure to put your information in the chat box and stuff like that. So if people have other if they think of other questions after the program, they can reach out to us at any time.
We've often come in just at that point, to kind of help with, okay, here's the situation, and we don't know how to make this decision, and we need some guidance and support in being able to navigate this conversation, and we can come in and support with that.
Yeah. So, Tracy, this is a great question. Thank you for asking it, because I was going to ask Stacy that as well. What if the parents are unwilling to have the conversation? Is there any advice that you can give? Please do so.
So again, number one, keep trying. Number two, I think sometimes it's how you phrase it, through life. And anytime somebody says we need to talk, your guard automatically goes up, and that automatically, you feel anxious. You feel like, well, what is it? Whether it's a significant other or a boss or a friend, if someone texts you or says the words we need to talk, that's like the ... it just raises anxiety. So I think removing some of that from it, you don't have to formalize it. You don't have to make it this, we need to have this conversation and I'm coming over Sunday night to talk about this, because that obviously is going to raise the anxiety. So I think if you're making it, through informal conversations, and sometimes it's much more palatable. And I think sometimes we have the best conversations when it's, and I'll give you the example. I had a client that, one son one day said, Mom, I think it's time to make a move and blah, 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 blah. And, presented it in this kind of formal way. And she absolutely went off the hand, just was so angry, called me angry, called everybody angry, was for days. I wouldn't speak to him. Her daughter said, hey, Mom, I was talking to my friend so-and-so, and she said her dad was just moving into this great new community, blah, 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 blah. And she said, oh, that's a wonderful idea. Oh my gosh, that's fantastic. Can you? And she would then call the son and say what a wonderful idea his sister had. And she called her brother, whatever. So when it came across as, Mom, I think we need to do this, guard went up and she was anxious. When it came across as, hey, in conversation, oh, by the way, remember your friend so-and-so, I just found out they moved to this place in Inglewood and blah, blah, blah. Oh yeah, I know about that. And oh, that sounds fantastic. You want to go have lunch with them? Sure, sounds great. All of a sudden it was like the best idea since sliced bread. So I think sometimes it's how we wrap it up, and sometimes it's how we talk about it. I think also check yourself, because sometimes if we go into conversation with our notepads and notes and kind of formal, okay, I need to talk to you, but hold on, let me a second, let me just look at my notes, then automatically it raises the guard. If it's more of a just kind of woven into conversation about something else, it makes it easier. I have 3 teenagers, well, 2 teenagers and now one not a teenager anymore. And I have my best conversations when they're strapped into the seatbelt in the car and we're driving somewhere, and it's like, and oh, by the way, this, rather than, come to the table after dinner and let's talk about this. So approaching things that are not so comfortable for teenagers to talk about sometimes is much easier when it's just an informal, woven in through other things. Can I go to the mall? Sure. When are we going to talk about college applications? Let's go to this mall and then Starbucks. So when you informalize it a little bit, when you weave it into other conversations, I think it's a lot more palatable.
Yeah. And also you mentioned this at the beginning, but try again.
Try again.
Yeah.
Try again. These are important conversations. So it can't just be, again, if you're a healthcare proxy and you've never seen the advanced directive, try again and say, this is really important, Mom. You've named me the healthcare proxy. I have no idea what's in it. I want to advocate for you. I want to make sure that your wishes are honored. Can I see the advanced directive? Can we talk about it? Can I just look at it first? And then I'll, follow up with any questions I have. Because I think if they're understanding that's so important, and I think that's definitely one way, is you want to be able to advocate for them as much as possible. Don't give up on it. It may not be comfortable, but some of the most important conversations we have in life are the ones that are the most uncomfortable. And it doesn't mean we don't have them. It just means we find a way to make them happen.
Right. Such good advice. Does anybody have any more questions before I turn the program over to our legal expert? And don't worry, if you think of questions to ask Stacy, just put them in the chat box and we can come back to them.
I just want to, because Tracy just commented
Oh.
something, and she's absolutely right. It's a matter of, that you're not, I think very often people are afraid of having the conversation because they're afraid of losing control of something. And ironically, this is about gaining control, so that it's not that you're trying to do something for them, but that you're trying to advocate for them. You're trying to help them, you're trying to be their voice. So this is something that it's like an extension of them rather than taking something over. And that's really important, especially as we're talking about our aging parents or grandparents.
Definitely. Thank you guys so much. All right, Jason. I am happy to have Jason involved. Jason Marks is a graduate of Boston University with a BSBA. He's a graduate of Seton Hall Law School. He's also a graduate of NYU School of Law. He has a master's of law in taxation. And he is currently the partner and chairman of the Elder Care and Social Needs Planning Practice Group at, and I hope I don't butcher the name, Curcio, Marzayan, and Surratt.
That's pretty good.
All right. Jason, please take it away.
Thank you. Thank you. It's I really appreciate being here today. Stacy, I think I give you great kudos on your presentation. I think, the toughest part of any kind of planning in advance is having that first conversation. But, once you've had the conversation doesn't end there. It's got to be put into effect. And everything has to be documented, because having the conversation at the end of the day, when the kids have to ultimately make decisions, could still, without the documentation in front of them, wind up into some kind of dispute. And, unfortunately, as we all know, as we age, the likelihood of diminished capacity becomes more and more of a reality, and we need to have these conversations before it becomes too late. And we need to effectuate those conversations and create the documentation that memorializes the intent and the desires and wishes of our parents and loved ones before they lose that ability to do so. So the first thing that I want to talk about is planning for diminished capacity. What are the tools that we use to meet those objectives? I want to talk about also protecting assets. How do we go about doing that, and what do we use to protect assets? And then I want to get into a discussion about capacity as it relates to different kinds of documents. So in terms of planning for diminished capacity, one of the primary things that I tell my clients is you need to name somebody who can take care of and authorize matters if you're not able to do so for yourself. And from a financial standpoint, that is a durable power of attorney. A power of attorney is a document where the individual who creates it, called the principal, names an agent, also called an attorney in fact, to make legal and financial decisions for them if they are unable or unavailable to make those decisions for themselves. Now, that power of attorney generally is effective immediately, but it could be effective only after the principal becomes incapacitated, and that's called a springing power of attorney. The benefit of a springing power of attorney is that the agent, who may not be ready to take over, or the principal may not find the agent to be ready to take over immediately, doesn't get the authority until the principal becomes incapacitated. The issue that we deal with when it comes to these documents is that we then have to have a determination of capacity, at least by a couple of doctors, to ascertain whether or not the named attorney, in fact, can take over the responsibilities of handling the finances and legal aspects of the principal's life. Oftentimes, what I'll do, rather than drafting a springing power of attorney, is I'll draft a immediately effective power of attorney and I'll hold on to it in escrow. And then, rather than having to get the doctors involved, the agent comes to me and I can work on it with the family to determine capacity. it alleviates some of the stress and some of the burdens that that the family would otherwise have to deal with in a very difficult and trying time. What does it mean that the document is durable? It means that I've created a document and I've named an agent for me, but if I become incapacitated, that agency, that authority still remains in existence. And that's very important, because if I have a power of attorney and I name my wife as the agent, I'm no longer able to function for myself. And if my wife isn't able to manage affairs for me, as my surrogate decision maker, then what was the point of me having her as the power of attorney? That's just really if I'm unavailable. But if I'm not able because of capacity issues, I still would want my wife to be able to write checks, pay bills, file tax returns, sell property, make loans, make gifts, whatever it is, engage in Medicaid planning, but whatever is necessary to do what's in my best interest. And it's important to also remember that the agent that you name carries with that a fiduciary responsibility to the principal, which means that they are responsible for doing and acting in the principal's best interest. Okay. From a healthcare perspective, the legal document that effectuates the surrogate decision-making authority is an advanced healthcare directive, which is oftentimes combined with a living will. And the living will is the document where an individual makes their last expression of what they want for healthcare treatment if they are in some type of persistent vegetative state, or if they are if they've been diagnosed with a condition where there is no likelihood of recovery. And it could range the gamut from keep me comfortable and let me go to, keep me connected to all means of artificial hydration, nutrition, and alive until some scientist comes up with the cure for anything and everything. Usually most people want to have that ability to die with dignity, and their living wills typically say, keep me comfortable, but let me go. But combined with that is, my documents at least, is a healthcare directive where we name someone as the healthcare agent. Now, one of the things that Stacy pointed out was, you could have a family with 3 or 4 kids, but you've named one person as the agent. What happens? The other kids can still challenge mom's wishes. Now, clearly mom's wishes are in this living will. Hopefully it's drafted tightly enough to meet all of these contingencies, but it may not. One of the things that I tell my clients they can do is, in addition to naming the one person who they think is best suited to make the healthcare decision for the parent, is consult. And we can draft into the document a consultation requirement. Before you make a decision, I'm requiring that you go discuss with your brothers and sisters about what the best decision should be, because the document may not cover every scenario and you may need to go back. Ultimately, the decision would be that of the person named as the healthcare agent, but at least they've gone back and they've had to talk with the family before that. Now, the living will and the healthcare directive is a legal document. There is the risk always that a healthcare provider or a hospital may not respect the document for whatever reason. It may not be properly executed. It may be missing a witness. It may not be notarized. The person who would otherwise have to authorize the use of the document just may be in a bad mood. There is another option. And I say this for some of my advanced senior clients, and that is a POLST, P-O-L-S-T, which is an acronym for Practitioner's Order for Life-Sustaining Treatment. And everybody hears life-sustaining, and it means that everyone can be kept alive. No, it means this is an express wish that you or your power of attorney has with your doctor to make a medical record a physician's order, a doctor's order that becomes part of your medical chart for life as to what you want in the nature of life-sustaining treatment. Do you want it? Do you not want it? When do you want it? When do you not want it? And you can have this in-depth discussion with your physician about how to address all of these issues. And, I know Stacy mentioned earlier that you should have the conversation with the doctor about the living will. I think, beyond the living will, for certain clients, it may be also recommended to have a discussion about instituting the pulse. It becomes a belt and suspenders, but it works well. Another tool used for planning for capacity or incapacity is a trust, a revocable trust. This is a great way to not have to, if you don't have a power of attorney, if you don't have a living will, but you've funded assets into a revocable trust, which during your lifetime you could change and manipulate and do what you want with and terminate it. But if you become incapacitated, now you've named, or hopefully you've named in the document, a trustee to take over in the event of your incapacity or your client's incapacity, who can then take over and deal with and manage all the assets that have been transferred over to the trust. It requires that during the client's lifetime, they actually transfer assets to the trust. But for those who are worried about planning for issues of incapacity, it eliminates that step. So you may have a power of attorney in place, you may have a living will in place. If a lot of times banks and financial institutions will not respect the power of attorney that I draft because it's not on their form. They will, however, respect a trust agreement and a trustee. It requires the actual physical transferring of title of assets. So if it's real property, you need to execute a new deed to transfer the property over to the revocable trust. If it's financial assets, you need to actually open up a new account in the name of the trust and title the assets and retitle the assets into an account in the name of the revocable trust. But it is a seamless way of having the next person in line manage your affairs to be able to handle your financial life and the legal issues that go along with the assets that are in the trust when you name somebody as the successor trustee. Okay. If none of those actions have been taken, then the only other alternative that remains is guardianship. And I say I say this as the last resort, because guardianship really means that you've now lost capacity. You don't have the ability to make decisions for yourself, whether it be for financial, healthcare, or other personal reasons. And you've not designated somebody or arranged to have somebody take over the control of your assets. And it requires then an action in court to have a judge declare the ward, the alleged incapacitated person, incompetent. And at that point, they lose many of their civil liberties. So it is a last resort. I look to limit capacity as much as possible, but where there is no other alternative and somebody needs to make a decision about where mom or dad is going to live and they haven't had that conversation with them and mom and dad hasn't taken it to the next level of having the documents necessary to appoint someone to make decisions in their place instead, then guardianship becomes the last available option. In terms of protecting assets, clients want to make sure that what they've saved, what they've worked hard for their entire life, pass to their family. And it's through a last will and testament or the revocable trust or another type of trust that families can designate who their beneficiaries will be and how the beneficiaries will receive those assets. How will they be protected from taxes? How will they be protected from claims of potential future creditors? How will the assets be protected from future divorcing spouses of children, surviving spouses, grandchildren? All of these issues are and should be taken into consideration when it comes to protecting an individual's or family's assets. With respect to trusts offer an enormous level of creditor protection and divorce protection, and I use those frequently for all of my clients. So now we've talked about planning for incapacity. We've talked about documents, briefly about the documents that are used to help to protect the assets that the clients have. Question becomes, if we've gotten to the point where we're concerned about mom or dad's ability to handle their own affairs, do they have the ability to even execute these documents? And so we have to go through, and I, as an attorney, as an elder law attorney, as an estate planning attorney, when I sit down with my clients to execute documents, I have to sometimes do an evaluation, my own evaluation, as to whether or not I believe the client has the ability to understand the documents that they're signing. Now, certain documents like a will or a revocable trust have a very low testamentary capacity requirement. Essentially, they need to have an idea of who their loved ones are, what their assets are, not even specifically, but an idea of what their assets are and where they are, and who they want those assets to go to. That's about it for testamentary capacity. It's about as low a level of capacity requirement as possible. The problem with capacity issues, and we've talked about this with respect to the power of attorney and the living will, is designating someone as the agent, is that those documents are a contract. They're a contract between the principal, they're a contract, and the agent. So the level of capacity that's required to execute a power of attorney, as small as this document might be, you could have a 50-page will or a 50-page trust and a 4-page power of attorney. The capacity requirement for a power of attorney exceeds that of the will and the revocable trust. It requires contract level capacity that the individual understands the nature and consequences of entering into that document. And we're not talking so much the person who's being named as the agent, but the principal, that they understand that they are giving authority to someone else to act on their behalf. And so this is an issue for a lot of my clients who are getting up there in age, because they may have the capacity to execute a will, but sitting down, they have no idea what a power of attorney is. I had, just as a quick anecdote, I recently had a meeting with a gentleman in an assisted living facility. He came referred to me through a friend, and then again through the relative of this friend of mine. I met with his uncle, and I sat down with him, and he was very nice, sat upright. He seemed very coherent and understood a lot of what I was saying. But then I had to talk with him about the power of attorney that he wanted done, or at least I was told he wanted done. And I said, "Do you understand what a power of attorney is?" And he had no clue. And I tried to explain it to him as to what it is. And then we talked a few minutes more. And then I went back and I asked him, "Do you understand what the power of attorney is?" And he still was not able to understand what it was. And at that point, I had to walk away, and I said, "I can't have him sign a document, because he doesn't understand the nature and the consequences of what he's doing. And it might actually be in his best interest, but as an attorney, ethically, I cannot go about having him execute a document." So there's quite a bit that's involved in planning for capacity from the legal perspective. The conversations, absolutely a must. And sometimes that it's not so much the conversation for mom or dad to say to the kids, "This is what I've done," but the more difficult conversation about, as Stacy so eloquently put it, "Mom, Dad, how you doing? There's some things that I'd like to talk about," and finding the best way to talk about it. And I think, Stacy, I think that was great. The suggestions that you had were terrific. And I'm planning on using those when I speak to my clients. But in the end of the day, you can have all the best conversations in the world. If it isn't on paper, signed, when the person has capacity, those conversations don't go anywhere.
And that's why both of you are here to discuss the Protect Your Life, because both of your professions really work very well together. So I do have a couple of questions for you guys. does a power of attorney need to be refreshed?
It should be. I usually tell my clients, you may not need to update your will or trust, as often because they may still carry, but I would say update a power of attorney every few years. Make sure that because those who are going to rely on it want to see something that's recent. It's worth it to take the time to do something like that.
Okay, good. Yeah, that's a great question.
I'd say every 3 years or so.
Every 3
have
years.
Have an update. Yeah, I mean, you see these documents that are 20 years old. It's not good anymore.
Yeah, and sometimes they're done by the real estate attorney.
Yes, and they're good for only the real estate transaction.
So I've got a question here that's pretty interesting. So I'm going to let Stacy take the first part of that, and she's probably going to throw it back to you, Jason. But is the document named 5 Wishes acceptable?
So 5 wishes, and I'll let Jason talk about legalities of it, but it is a great, it's a great actually way of facilitating potentially a conversation. If you want to sort of have some balance between formal and informal conversation, because 5 wishes really, it's maybe a prep document for an advance directive. I think it's a way of helping the conversation and ask some great questions, not just in terms of some of the mechanics of things, but goes more into some of those values and talks a lot about end of life things and what's important and whether you want music playing and things like that. I think it's sort of, so it's not just in terms of, would you want to be resuscitated and do you want a feeding tube and under what conditions, but it literally goes more into those values and the things that are most important. So I think, and again, I'll let Jason sort of answer more officially in terms of legalities, but as a social worker and doing some of these guardianship cases, I feel like I'm a social worker that speaks a little lawyer at times. I think that if it ever came down to something, I think that it's a good way of starting the conversation, but it should be like the rough draft of maybe a formal document. Or the way of having a conversation. And maybe there's ways of putting more of those things into a legal document. But I think that's, to me, it's a great way, and you can look it up, and it's a great document to sort of help have that conversation and talk about some things that maybe you don't typically see in an advance directive.
I mean, I'll admit I'm not familiar with 5 wishes, but what it sounds to me is a sort of a checklist of different things that you want to have happen at certain stages in life. From the legal perspective, if it doesn't meet the formalities and isn't executed with the formalities of a living will or healthcare directive, it's not going to be respected. So, in terms of having the witnesses, having the notary public sign off, you could have, again, you can put all your wishes in writing even, but if it doesn't have if it doesn't have the formality of the document that's required by law, by statute, then it's not an effective document.
I think too often I've seen, when there's no challenges to anything, very often, it can just be, oh no, I'm the healthcare proxy or something, and the ER staff member may not even be looking at it. But the times that it's going to matter the most is when there is challenges. And then I've seen people look at, tear it apart and say, well, it's now 5 years old, or, they missed, a period in this sentence. Therefore, the whole thing is. So the more they can have something to challenge, then it just adds more potential fuel to that crisis, so to speak. So I think, I'm a big believer in making sure that the things, just because you can download something from the internet, just because you can buy your own format staples, doesn't mean that you should with everything, because that's just going to add more potential conflict at the time, and have somebody else be able to look at it and say, well, this is valid in this state, but not this one. So I think those documents are great to have the conversation, to do your prep work. But yeah, they're important. And when something's important, you want to make sure that it's done, as Laura said in the beginning, you call the right professional for the right profession. And I think that you want to make sure that everything is officially legal and legit.
Yeah, the last thing you want to deal with in a crisis situation is another crisis. So one of the goals of these programs is to really get you to think about and plan so that it's a lot easier if something were to happen. So we have 2 more questions. Why have a power of attorney if it may not be recognized by others?
It's a good question. it is a legal document. It should be respected, but a lot of times healthcare providers, hospitals, they're concerned about their liability. And so it becomes, it becomes a balancing act between respecting the document and the wishes of the principal versus, how much exposure is the doctor or hospital going to put themselves in by following certain orders or engaging in certain treatment, which is why having that, belt and suspenders, having that doctor's order, you don't have to worry about it. Not everybody needs a pulse, by the way.
Right.
I usually don't recommend it for my younger clients, but I do recommend that they have at least a power of attorney and a living will with a healthcare directive, so that there is somebody in the unlikely event. But as individuals age and they become more infirm, then it really becomes more of a real conversation to have with not just the attorney, but with the doctors, and through the doctor's post document, that post written order, they can memorialize a lot of things that may not be necessarily incorporated into the advanced healthcare directive.
Right. Just two things. So in terms of the power of attorney, I know very often I've seen someone walk in with a power of attorney document and they don't realize that just because they're power of attorney over real estate and finances and everything else, there's nothing in there about the medical component. And unless they have a separate healthcare proxy where there's that medical part in there, then they're not the medical healthcare proxy. And again, they could have decision-making abilities over the billions of dollars somebody has and all of their properties and everything else, but not their healthcare. And people don't often realize that. And another thing, in terms of the post, that is something I've spoken literally all over the country about the post when it first came out in New Jersey. And I think one way of looking at it is it's also, and it's definitely not for everybody. It's sort of, often when there's more of a end of life diagnosis, potentially, or you have something more, life threatening, but it's sort of, it takes that advanced directive. It's not in place, the advanced directive, but it takes the advanced directive and it sort of puts it in the front of the chart in a 1-page, easy to read, bright green document. So that the doctors and nurses don't have to be looking through an advanced directive and try to interpret it. So it's taking that advanced directive that you may have created however many years ago and saying, okay, well, now let's talk about these conditions because here's where they are with something. This has been met, this hasn't been met. Therefore, what do you want to do about this? And it creates it into an order so that everything is an actual, medical order, and it doesn't then have to be kind of, interpreted in that advanced directive. So it doesn't take the place of it, and it shouldn't. I still think that advanced directive is such an important document to have, but the pulse is then often like that. And I love that belt and suspenders. I wish I had used that when I've been talking about the pulse, because that's fantastic. It's a great way of thinking about it. So I think that, and it also, as Jason said, it helps facilitate the conversation with doctors, because too often most people don't even talk about their advanced directive with their doctors, and the doctors really should be very involved in that conversation, and the doctor should know what their wishes are as well. So the pulse forces the doctors into the conversation.
And since it's not a legal document, the issue of capacity is also different.
Yes,
so you can have a conversation with the doctor who can place it into a post,
right,
where a person might not have the capacity to sign a living will.
Right, absolutely, because the doctor is the one that's signing it, or in a proxy, or a daughter or somebody, it's a surrogate, the wording is different. So it makes it a little bit easier to have a loved one who knows you very well be supporting that conversation, because it's the doctor writing an order based on what your values are, what your wishes are.
See, we really work well together as a team. Like it really, it's really beneficial to have almost like a team of healthcare providers behind you, so that everyone is on the same page, because it sometimes really does take a village to take care of one person.
Absolutely.
It does.
And, people shouldn't have to go through this alone. It doesn't, even though, and it's funny because even though you may know a lot of the things, and even sometimes we're in this field, but you need to kind of remove that professional hat and rely on other professionals at times. So I think it's so important to lean on each other and be able to have that team of professionals and that can collaborate together.
It's really okay to ask for help too. So before we wrap up, I have one more question. Are you familiar with the concept of a caregiver contract in order to define the role of family caregivers and to protect their interest after the loved one dies?
I'm familiar with caregiver agreements with respect to Medicaid planning, but not so much, protecting interest after the loved one dies. I mean, after the family member passes, it's really going to be about their will, what they've done to plan in advance for their estate to make sure that everything passes to those to whom it should go and in the manner that it should pass. Caregiver agreements are important in terms of proper spend down plans for Medicaid planning, because without that, if you are hiring somebody to provide care in the home and you don't have, and the future Medicaid applicant doesn't have an agreement with the caregiver, then any payments will be treated most likely as uncompensated transfers by Medicaid, which will result in a Medicaid transfer penalty that could set back an individual, several months, if not longer, as far as becoming eligible to receive Medicaid benefits. If there is an agreement in place and it's properly structured with a reasonable rate established, depending, and that reasonable rate depends upon the nature of the services that are being rendered by the caregiver. But if there is a pre-existing an agreement which creates that legal obligation to pay, then the payments that are made should be respected by Medicaid, by the County Board of Social Services when applying for Medicaid benefits.
Thank you so much. All right, guys, it looks like we've come to the end of our program. So I want to thank all of you for being here. We've really enjoyed our time and we hope that we gave you a lot of information. I put all of our information in the chat box. So if you want to grab that, that would be great. But what I'm also going to do is send everyone who's attended here today a wrap-up email with all of our contact information. And it will also have the 2 upcoming programs, because we have 2 more on our Get Control of Your Life series. So the next one is going to be May 18th at 12 p.m. and it's Declutter Your Life by Lisa Harris from Organize with Lisa. And then our 3rd program is going to be June 15th, 12 p.m. and it's Sweeten Your Life by Heidi Gross at Autumn Years. And she's going to tell you some really fun things that you can do with your retirement, your golden years. So thank you guys again for coming here. And what I'm also going to be doing is setting up the wrap-up email, but I'm also going to be posting this on our Facebook page. So please follow us, Generations Counseling and Care Management, and you'll get to hear the whole program for those of you who have joined late. Again, thank you guys so much. I hope to see you next time. Bye.